Okay, we are all set to call the meeting to order. Thank you.
Thank you. I just noticed that. All right. It is 9:30 a.m. So we are ready to call the meeting to order. So I will go ahead and do that. This is the open meeting of the Citizens Clean Elections Commission for Thursday, March 25th, 2021. And it is 9:30 a.m. I'll go ahead and, for item 1 on the agenda, call the meeting to order. If I could ask any audience members, oh, and I see Commissioner Titla has joined us. Excellent. Ask any audience members to please keep their microphones on mute. And with that, I'll go ahead and take attendance. Commissioners, please identify yourselves for the record, and perhaps we could start with Commissioner Titla.
He's muted.
Yes, Commissioner Titla, you are muted. There you go.
Yes, yeah. Aye, here.
Thank you. Commissioner Meyer, do you want to identify yourself?
Damian Meyer.
Thank you. Commissioner Kimball?
Commissioner Kimball, I'm here.
Commissioner Payton?
Mr. Payton is here.
Okay, and I am Commissioner Amy Chan, and I am also here. And with that, we can move on to item 2, discussion and possible action on commission minutes for February 25th, 2021. Any discussion? I don't see any discussion. And if not, do I have a motion to approve the minutes?
This is Commissioner Kimball.
Motion to-
We approve the minutes.
Commissioner Meyer, second.
Okay, we have a motion to approve and a motion to seconding. I'll go ahead and call the roll. Commissioner Titla, how do you vote?
Aye. Aye.
Thank you. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball, how do you vote?
Aye.
Commissioner Payton?
Aye.
And I vote aye as well. Right. We have approved the minutes for the February meeting by a vote of 5 ayes and 0 nays. And with that, we can quickly move on to item number 3. Discussion and possible action on Executive Director's Report, enforcement and regulatory updates and legislative update, including election and administrative bills, such as House Bill 2014 and House Bill 2110. Tom?
Yes, Madam Chair, Commissioners, thank you very much. I'll try to hit the high points here just as quickly as I can. I think the big hang on, I myself am having a technical difficulty here. I apologize. Let me find my way here. Well, I'll start by saying, obviously, you can see there's a full calendar of voter education activities. In fact, today, Gina, Alec, and Avery are at a conference, online conference on social media effectiveness, which they've done. This is the second time I believe they've attended that conference, and we found it pretty helpful in keeping keeping the commission's voter education stuff in line with industry, with the still developing industry. We are excited. Gina and Avery have been invited to participate in the CE2 Educator Conference, which is a opportunity which involves an opportunity for them to meet with civics educators around the state, Avery's also met, which I think is great, with both the Arizona State College Republicans and the Arizona State College Democrats leadership. And Gina is continuing to participate in the Secretary of State's election security meetings. A couple of things to check out on the website if you're interested. We have launched a webpage with information on redistricting, specifically to try to make sure that folks, if they're inclined to follow the redistricting process, have an understanding of what it means to voters specifically, because obviously a lot of redistricting stuff can get into the weeds. A couple of quick highlights, and then I don't want to delay this, or I don't want to have this go too long. We're still waiting for a decision in the Legacy Foundation Action Fund case, which has been pending at the Court of Appeals, we think, since December. Couple other things. We have 2 rule amendments on the agenda. We've had the opportunity to work with the governor's office and with some of the members, or at least one of the members of the Governor's Regulatory Review Council in how to go forward with this and make sure we're adhering to the governor's rule guidance. So I specifically wanted to thank Nicole Collier, who's the governor's assistant general counsel, or deputy general counsel, I'm not sure if I have the title right, for helping me go through those issues. We had noted on a prior regulatory framework, a regulatory issue, that we weren't clear where we were with respect to how our rules and the statutory formula for reducing state and legislative contribution limits worked. We have had a good conversation with the Secretary of State's office, and we actually are on the same page about that. And I also want to thank Corey Lorick, who's the Election Services and Compliance Manager at the Secretary of State, for her help with that. Finally, I wanted to mention to you all, we've been approached by a staffer for Corporation Commissioner Justin Olson about the Corporation Commission's forthcoming, I gather, ethics rules. One of their ethics rules, as I understand it, has to do with whether or not folks who have business in front of the Corporation Commission, what that would mean in terms of recusal and those kinds of things. So what we got the question was, if a Corporation Commission candidate wanted to add language to their $5 form, which you can individualize under our rules, would that be an issue? And we've concluded that would not be. It would be simply as a matter of course. If someone adds information that's not needed but is not wrong or misleading, our policy would be to approve it generally. And if you have supplemental questions, Mike can speak to them. But as a general proposition under our rule, we're looking for making sure that the material that has to be on the form is on the form, so that the form's valid. We obviously offer copies of the form. You can print out the form, the stock form for the $5 qualifying contributions, but candidates are allowed to make their own. So that's where that is. And then lastly, I know we have, or I anticipate we have one. You should have received today a complaint that you may not have received previously from Heather, and I'm going to butcher her name. So Marowick, I believe, who is a complainant against a participating candidate named Ryan Starzyk. I did what we under our rules is an administrative decline on that complaint. Our rules do say that I'm to provide you all notice, which I do, as you know, and many of you know in the past, that's in the enforcement section. But the reason for giving you all the notice is to provide you an opportunity to ask about that. Also gives an opportunity to a person who doesn't think that the conclusion that the staff reached was correct to speak on that. And then the last thing I want to add on this before we get into that, assuming she's here, is the way this rule is intended to work. It's not supposed to develop a hearing because the respondent may or may not be here and may or may not, but although they're aware of the circumstances, the goal here is, if you all desire to, is to simply direct staff to reevaluate the closure. I think I'm stating that correctly, and I will leave it to, I think I've said it correctly, but I'll leave it to Kara. I'll put her on the spot to correct me if I've said anything wrong. So with that completes my report. It looks like Heather is on the line. So however, Commissioner Chan, however you want to recognize her, I think
Sure.
that's all we need. I think that's what we need to do. And Kara, obviously, if you want to jump in anytime I've said anything incorrect, please do.
Thank you, Tom. Kara, did you need to add anything to what Tom said?
No, I was just going to say that is correct, and I appreciate him for raising the hearing part. The fact that this can't go too far into the merits of the complaint for those reasons.
Okay, thank you. Okay, now Ms. and I don't want to. Maybe you can tell me how to pronounce your name.
Actually, Director Collins was pretty close. We say Morawick.
Morawick. Thank you, Ms. Morawick. And Tom had sent us the closure email that he had sent you, and I did ask him to send us your complaint because, and he may have shared it with us before. After reading the closure letter, I just wanted to have it available, and because we can't go too into the details, but I wondered, did you want to speak to the commission today about the closure letter?
I would love to. I appreciate that. And I understand we can't go too into depth, but the essence of the complaint is that Facebook in 2019 decided upon some political transparency rules. And so they started reporting exactly how much money they received from any political campaign in exchange for advertising. So in this case, the campaign of Dr. Ryan Starzyk spent, according to Facebook, $2,500 on advertising on Facebook. That was 50 ads over about 18-month time period, includes before and after funding. And none of that expense appears on Dr. Starzyk's campaign finance reports. There's no payments apparently to Facebook. So that discrepancy, either it's somewhere in the report and not readily available, in which it can be cleared up by him he can easily download a report, shows where all the payments came from, and that would be great. But if he missed logging those expenditures, because his reports balance, he took in contributions and he had expenditures that are the same. If you add $2,500 of expenditures, you have to also add contributions. If they were paid for out of his non-campaign account, they would be considered in-kind contributions. These are ads that say paid for by the Ryan for Arizona campaign. And I have provided all those in the complaint in a big stack printed out. So I would appreciate if we did have an investigation to show who paid for those ads, were they accounted for? And if they weren't accounted for, how much of it came from his personal account or from others? Did he exceed contribution limits? And if so, did that happen before he applied for clean elections funding, which would mean he had, and I as a treasurer know how serious filing reports are. It's a perjury to file an incomplete report. So I just think an investigation, him downloading the reports, seeing if it's accounted for somewhere in his report, and if not, what the consequences are. Depending on how those ads were paid for, there's a whole series of different laws that can be broken like a little chain. So I would appreciate it if the Clean Elections Committee did do an investigation and we can resolve the issue.
Thank you. Ms. Commissioner Kimball, do you have a question?
Well, I guess I do to Kara. So I don't understand what our limitations are here and what we should do about that. So if I ask Tom to respond to that, is that going to be a problem? And since we don't have the other party here, I mean, how would you recommend we proceed on this?
You can't take action in terms of finding a reason to believe or something. You can ask Tom questions. He can respond to you. Ultimately, the decision is really, do you direct Tom to go back and continue investigating, or are you fine with Tom's conclusion and rationale as has been explained in the email for administratively closing the complaint? So you can ask questions, and it would be fair for Tom to respond, to provide his explanation and his rationale.
Okay, well, given that, Tom, I've read the original complaint, which I think I've read before, and I read your response to it. And I've heard Heather's, and I apologize for using your first name, but it's safer, I think. And I understand Heather's point, which she made also in this complaint. So could you address some of what she said this morning?
Madam Chair, Commissioner Kimball, I certainly can try. I would say this. I mean, and I think when we looked at the complaint, as I evaluated the complaint, I focused, and I think I've expressed this to Heather as well, that I focused on the bottom line of the knowing violation of the limits. That having been said, and the limits that sort of, if you look at the way the complaint's structured, it's this part is, I found, I mean, I think this is very clear, the allegation to say, this person may have violated the personal contribution limit, they may have violated the primary spending limit, and then there's obviously a knowing violation of those has some of the consequences that Heather mentioned. That said, that was the targeting, or the way that it was put together. I don't. But as far as that's just how it's put together. I don't have any. I don't have a position personally on sending this back to me to review or not review. I feel. I mean, I don't know if I guess I should. Assuming I can say that. I mean, I just don't. I mean, I think that if that's the commission's inclination, that's the commission's inclination, and that's the rule is supposed to be set up in order to facilitate this. This happens to be the first time we've had someone actually take advantage of this rule and the way it's supposed to work. So, our explanation was basically based on focusing on those limits and how we thought that those limits worked in conjunction with some assumptions based on the facts presented by the complaint. But to the extent that, but like I say, I recognize, I mean, I'm not, I don't know how to put this other than we don't have any pride of authorship associated with it. The goal here is to make sure we get the process right. And so I don't have any position on beyond that.
Madam Chair, Tom, I just want to make sure I understand this. So do you and Heather have a difference of opinion on the facts or on the consequences? Because in your response, a number of times you said, if this had been brought to the attention of the commission earlier, it probably would have been a warning or a request to fix records or other things. So is there a factual disagreement with you, or just what should be done about that?
I think, excuse me.
Please.
Go
Sure.
ahead, Kara, if it's to
Sure,
that
Moment.
point or about the, where we're
I
going.
think that, asking Tom to state his position that's been on the record is one thing. And then trying to kind of suss out the distinctions between the complainant's perspective and the staff's perspective is we're getting to that line. And all due respect, Commissioner Kimball, I'm sorry for cutting you off, but like Tom said, we are trying to get the process correct. So that's really what we're trying to do here. So let's try to avoid that kind of questioning. And, to the extent you want that explanation, we can staff can try to provide some of that information if the commission decides to send it back.
Okay.
Does that make
Okay.
sense?
Yes, it does. Thank you, Karen.
And just to amplify that, I mean, staff, my view is, as a staff member, is we're in a position where we're here to, if there's an issue, commission has questions, absolutely want to get those answers. So having it sent back is like I said, we have no objection to that.
This is Commissioner Payton.
Commissioner Payton, go ahead.
I'm troubled by the fact that the person that the complaint goes against isn't showing how those were paid for, those ads, and some of this is hard to understand why the complaint wasn't why it was closed to me. And so for my reasoning, I think that I don't really understand why it was closed in that respect. If $2,500 were paid for for Facebook ads, and it's not shown in his report how it was paid for, that troubles me.
Thank you, Commissioner Payton. I think what I'm hearing, and I'm sorry, Tom, if you would like to respond,
Nope.
Okay.
I have no interest in responding.
Okay, I just would like to say that I think that's exactly, Commissioner Payton, why Tom wrote us the email and wrote to Ms. Mrawiak, I hope I am pronouncing that correctly, and please forgive me if I didn't after you told me how to pronounce it. And that is precisely why he wrote the email he did, to explain why he was closing it and gave us the opportunity to say to him whether we agree with his decision or not. And I think what I'm hearing, and I know for myself, I think what I'm hearing from you and Commissioner Kimball, maybe what I'm feeling, which is, I think I would like him I'd probably like to send it back to him to reopen it and give it back to us to consider, if that's the right way to think about it. And Tom, would that be the right way to think about it? And do we need to vote on that, or just tell you that if that's what we want?
My understanding, or when we put together this particular rule to allow this kind of closure with a post hoc, or not post hoc, with the ability to not, with this process, the goal is to get direction. I think I have a pretty clear consensus from those commissioners. And so I don't believe there's a vote to be had. I think it's simply we will do that.
Thank you. And thank you for your work. And thank you, Ms. Mrawiak, for filing, for coming to the commission with this. I think campaign finance is always fraught with, lots of facts and details, and frankly, it makes my eyes go cross when I try to think about all the numbers and the details and things like that. So having it simplified by people who file the complaints and Tom looking at it and things like that is always very helpful. Even when he's, making a decision to close it, presenting it to us helps boil it down. So thank you to both of you for presenting those to us.
And I appreciate the commission taking the time to listen. Thank you.
Of course. Anything else on that? Okay. All right.
Okay, so if we're good with that, I just wanted to really quickly hit a couple of legislative things, but I don't,
please.
but I don't
Yes.
know if that's good with everybody.
I'm fine with it. I think we're moving on from that. And yes, please go ahead, Tom.
Okay. So on the legislative front, I just want a couple of quick updates. As you, even through yesterday, the bill that would add additional paperwork to the process of getting a mail ballot, that came out of committee yesterday, out of the House Government and Committee, House Government and Elections Committee. The two bills we've highlighted for the elections purposes, 2014 and 2110, are out of committee. 2014 is sort of self-explanatory. 2110 is interesting. A couple of developments there that are worth noting. One, the legislature, in an attempt to somehow make this a more, palatable bill to someone, changed the work requirement sentence to a sentence of choice. I'm not sure that deals with the legal problem there in terms of when you're substituting work for the surcharge. Our big focus in this is then the fact that they're notwithstanding the surcharge here, which is the functional equivalent of the same thing they're doing with respect, for example, to Prop 208. In terms of just saying, well, this was this, but we found a way to rewrite the law around this issue. We still think that's wrong. The other thing the legislature's done, which I think will be a significant problem, is that there was a bill in the House to eliminate juvenile financial sanctions. Now, I don't pretend to have I've been a public defender. I've never been a juvenile public defender. The problem with, so this addition sort of is designed to do two things. One, obviously, I assume it is to eliminate financial penalties for juveniles, which, whether or not that's how that's written and how that works under the Clean Elections Act, the VPA, is one thing. The essential effect of it, however, is that it makes our legal position look like it's harsh, right? So we will be in front of the Senate saying, you're doing this illegally, and yes, that may include juveniles also. When you're making a legal argument, the best political response is to try to extend the legal argument to some place where everybody would say you're incorrect, or you must be crazy, or why are you letting the law get in the way of a good thing? And so I think by larding this up like a spitball, the folks who the powerful folks who want this bill to pass really want it to pass, and the statistics we've been able to gather from JLBC say that this is a completely ineffective criminal or civil justice reform measure. So the goal will be to say, essentially what they've set up is kids who are guilty or adjudicated responsible for certain financial issues should be let go, and your concerns about the way the fund's set up and the fact that this actually is an ineffective justice reform are just, we're letting the perfect get in the way of the good kind of an argument. So that's where things are. We're hopeful to continue to try to make those arguments. We've made them, in writing typically. We haven't had to appear at the Senate, and so that's where we are. So a number of bills, 1485 is another bill that we've had an eye on. That bill also is moving. That bill is the one that it seems to have some ambiguity in it with respect to how many elections one would have to not participate in before one would be have to re-sign up for the PVL. Those bills are all moving apace, and so we'll see where we get. I don't mean to circle back to that, sort of awkwardly, but I just wanted to make sure that if you had any questions or thoughts on that you're aware of where we are on that process. So that's all I had on that, Madam Chair.
Okay, thank you so much, Tom. Any comments, Commissioner
sure.
Kimball?
Yes, Tom, in relation to 2110, so does it look like it's going to pass?
Well, it looks like it's going to pass to the extent because there's 16 Republicans and 14 Democrats.
Yeah.
And the vast majority of these election bills have passed on 16-14. The hard part about clean elections is that there is a committed group of Democrats who don't like it. That group is much larger in the House than it is in the Senate. So our main goal, frankly, is to hope and to work to have this not get a 3/4 vote. The House Rules Attorney is provided the argument to the legislature as to why this does not violate the Voter Protection Act and does not yield an amendment that requires a 3/4 vote. We spent time with that analysis. We think that analysis is incorrect. And so we do think that keeping the vote under 3/4 is key. I think that, so whereas some election bills that are clearly sort of red-blue election bills, those are easy. Those are all going to go, there may be a marginal Republican who can tilt those one way or the other in the Senate or House based on the margin. But on a program such as ours, where there's a particular faction of the Democratic caucus that's deeply committed to undermining clean elections, makes this a bigger challenge. It's not a red blue thing. It's an institutional power versus the sort of public-minded notions behind the Clean Elections Act. So
okay,
we're doing the best we can,
right.
and trying to make it clear what the legal issues are. I'll say the one difference we've made in this, the one different tactic we've taken in this is based on JLBC received numbers from the courts about what percentage of defendants have been able to take advantage of a similar work diversion program that exists. And their number was 1% to 2% of defendants. So if you're going to not withstand the Clean Elections Act altogether, including its funding, in order to assist at most 1% to 2% of defendants, because, and I can say this as a former public defender and among my former colleagues and current peers, those kinds of work requirements are essentially too expensive in terms of time to make up the difference for the fines and fees that we have in Arizona. The Clean Elections Act surcharge is something like 12.5% of the total fees, which is something like 6% of the total civil fines. But if no one can use it, you're notwithstanding the Clean Elections Act for nothing, essentially, for a percentage of people. What would need to happen, and what we're not opposed to, is a real civil and criminal justice reform measure that did not damage the Clean Elections Commission's funding source or obliterate it, as the notwithstanding clause does. So I don't mean to get it too far in the weeds, but we have been a little more aggressive than we would otherwise be about the ineffectiveness of this as a civil or criminal justice reform measure. This
Okay.
isn't the real deal.
Okay, thank you.
Thank you, Tom. Anyone else have any comments, questions for Tom? Okay. All right. I always feel so defeated after we talk about legislation. Okay, thank you though very much, Tom, for the work you guys are doing for us over there, Mike and Julian too. So I think we can move on to item 4, which is discussion and possible action on the following 2020 general election candidate audits. And we're going to have Mike make some general comments on this item, right?
That's correct. Thank you, Madam Chair. Commissioners, good morning. Before you are general election audits. As you're aware, the commission audits all clean elections candidates, either in the primary or in the general. These audits, just as they were in the primary, are very good audits. Our auditing firm that we work with, Preston Chapman, and the candidates and their campaigns worked well together. We were very happy with the results. As you've looked through them, there are some minor issues here and there, but they have been resolved or getting resolved. Nothing has rises to any major complaint or any major issue. So we're very happy with all of these audits. This is just the beginning. There will be more on the commission meeting for April, and that should wrap it up. And so with that, like I said, they're very good audits, and I'm happy to answer any questions, and I ask that you approve those audits.
Comments or questions for Mike? Okay, hearing none. Is there any comments from the audience on this item? And if so, you can signal the moderator.
I would just say, this is Commissioner Payton. I would just say that
go ahead.
I'm just glad that we're doing all these audits, and it's because of what has happened in the past, and having very small things, whatever, that makes me feel good that we're trying to keep everybody on the straight and narrow.
Thank you, Commissioner Payton. It does feel good to have this done and, you know, have good results, truly. So thank you, Mike and the staff. I'm glad we decided to do that. I think it was a good decision. So if there's no further discussion, I will entertain a motion to approve the audits that are identified on the agenda.
Commissioner Meyer, I move that we approve the audits identified on the agenda for today's meeting.
Thank you. Is there a second?
Commissioner Kimball, second.
All right. We have a motion and a second. Commissioner Titla, how do you vote? Commissioner Titla?
Aye.
Thank you.
Aye.
Thank you. Commissioner Meyer?
Aye.
Commissioner Kimball?
Aye.
Commissioner Payton?
Aye.
And I vote aye as well. And by a vote of 5 ayes and 0 nays, we have approved the audits identified on the agenda.
Thank you.
Thank you all. Item 5, discussion and possible action on amendment to R2-20-101 definitions. The commission may vote to begin the public comment period for a rulemaking related to this item. So we're going to try to bring out definitions and rules in line with the outcome of AZAN versus state, which was dealing with certain cross-reference definitions in the Clean Elections Act. So we're amending the definitions of the rules, and Tom is going to give us details. So please, Tom.
Okay. Yes, thank you, Madam Chair, Commissioners. So, yeah, we have 2 rules, item 5 and item 6. Item 5 is, so In Senate Bill 1516, the legislature expanded the definition of family members to include aunts and uncles and a couple other things. We have had a rule in our books that has a narrower definition. This has caused some confusion over the last couple of years because of 1516 and the outstanding litigation. The effect of the two, because of the cross-reference, the way the cross-reference is used in the Clean Elections Act, the effect of expanding the definition of family members for non-participating candidates has the reverse effect on participating candidates. In other words, whereas that definition now expands people who are not covered by the contribution limit subject to that traditional candidates are subject to, it actually expands the world of who's considered a personal or family contribution under the Clean Elections Act. As a result, a candidate who is clean, who gets a contribution from their uncle, has to count that towards the limit on personal family contributions, where they would not have had to do that previously. Nevertheless, Azan v. State more or less stands for the proposition that the legislature can do a lot with these footnotes before they cross the line. We feel like after a few years of this and having gone through litigation, I feel that we need to have a rule. I mean, we've had these sort of tension between our rules and the statute, and it's something we can take public comment on. Obviously, that's the whole purpose of this enterprise, is to open public comment. We probably will get some public comment on whether or not that's consistent in some people's views with Azan and the outcome. Other people will take different views, but our starting point is what's the cleanest way to make sure that the Clean Elections Commission's rules line up with the statutory definitions. And in this case, we recommend taking public comment on deleting the more narrow definition of family members that is included in R220-101-13. So that's, if you have any questions for me, Madam Chair, Commissioners, that's what we're trying to do there. And obviously, Mike, if there's anything I missed there, let me know. Yeah. So, but that's so we're recommending we open this up for public comment. We may get some, but ultimately we wanted to start with the cleanest amendment and see where we go from there.
Okay. And Mike didn't have anything to add? Okay, thank you, Tom. Any questions or comments from commissioners? Okay. If there's no further discussion, I will entertain a motion to propose the amendment to R220-101 to be published for public comment.
Madam Chair.
I make that motion, Commissioner Chair.
Oh, all right. Commissioner Titla has made the motion. Thank you. Do I have a second?
Commissioner Kimball, second.
Thank you. We have a motion and a second. I will call the roll. Commissioner Titla, how do you vote?
Aye.
Thank you.
Aye.
Thank you. Commissioner Meyer? I think I saw you speak, but didn't hear you.
Aye.
Thank you. Commissioner Kimball, how do you
Aye.
vote? Okay. Commissioner Payton?
Aye.
Thank you. And I vote aye as well. And we have voted 5 ayes and 0 nays and approved that for publication for public comment. And with that, we can move on to item 6. While I turn the page. And it's like the previous item, this amendment is to address as Azan versus state. And Tom is again going to speak about this proposal.
Right, Madam Chair, Commissioner. So R220-109 is,
we didn't roll this up in the last one, did we?
This has been, R220-109 has been, it's been a lot of things. It's been a topic of discussion for many years. So So basically, the upshot of the ASAN case, so when the legislature passed Senate Bill 1516 in 2016, they drew a circle around IRS recognized organizations, regardless of their nature, and said that they shall be treated unlike any other political spenders in state law and shall not ever be able to be a political committee. We and ASAN and the Democratic minority and some unions all were involved in litigation brought by ASAN on this issue. On the cross-reference, we were not successful. So what this rule does is what this amendment does is to say, look, we have a formula that we developed with the Center for Competitive Politics and lawyers associated with them. So which is to say, it's a formula developed with a group that is seen as a pro-free speech, a more of a not a group. So we think with a formula it has some bipartisan, cross-ideological content, but we want to make, and we think that's important because determining the primary purpose of any organization, even if it's accepted by the legislature, still in staff's view requires something other than primary purpose means primary purpose, because primary purpose doesn't tell you when, doesn't tell you what, doesn't tell you time frame, any of those things. We have a formula for that. So we believe, and we've started the process of working with some of the GERC counselors, including I had a very wonderful email exchange with Councilmember Sun about making clear that, putting aside what anybody thinks about political committees, this will not apply to those groups that are set aside by the legislature for different treatment. So that's why the language of the amendment says, where you get into the formula, it says, subject to 16-901-43, which is the definition that says, notwithstanding any other rule, there's no way you can't, these IRS-enabled organizations are not subject to these parameters. And it also notwithstands any rule that we have to the contrary. I don't believe there are any other rules to the contrary, but nevertheless, as we did with Prop 306, I think it's important to just say, look, it's not just subject to, but if there's anything inconsistent with that, where somehow we're going to get an IRS involved person here. Okay, so that's it. So basically, the bottom line is, we would, under this amendment, we would never apply our formula for political committee to an IRS recognized group, which is what the legislature wanted us to do when they passed 1516, and that is the result of the ASAN case. One caveat: this does not affect the Clean Elections Act so-called trigger reports, which have nothing to do with political committee or IRS status. They apply to spending, qua spending. So that's it. So we believe that, obviously, again, we may get comments to say go broader. That we may not, but at the very least, this concisely says, if you're in an IRS category identified by the legislature, the rules, the formula will not be applied to you because you are just not subject to the rule. So that's where that is. We think that again, it's better to simply move on, and the fact that it doesn't touch the trigger reports, which frankly, when it comes down to trying to track real spending in real time, are really the only tool left in the state's toolbox for that kind of disclosure. This seems like, again, the best, cleanest way to proceed to get public comment.
Thank you, Tom. Any discussion or questions?
Madam Chair.
Oh, yes, Commissioner Kimball.
Let me just say, despite reading this probably 10 times, I remain befuddled. Nonetheless, I would like to make a motion that we open R2-20-109 for public comment.
Thank you for that motion. Excellent. Is there a second?
Commissioner Meyer, I'll second the motion.
Thank you, Commissioner Meyer. All right, I will take a roll call then. Commissioner Titla, how do you vote?
Aye. Aye.
Excellent. Thank you. Commissioner Meyer,
Aye.
Commissioner Kimball,
Aye.
and Commissioner Payton.
Aye, and I'm
Okay.
equally befuddled.
I also vote aye.
I'm happy to take anytime anyone needs to try to unbefuddle. The bottom line is that we didn't make the problem. We're trying to fix the problem. We went to court. I mean, other people went to court and we went with them on the problem. It is, I don't know.
Everybody's befuddled.
I don't
But
have
at
a
least-
better.
At least we are. We have voted to publish our rule for
Right.
public comment. So
Right.
that's the good news. And
Right,
everybody
right.
will be befuddled with us, and we'll probably get lots. Well, maybe we'll get lots of public comment. I
Well,
shouldn't.
I
assume.
think this is a good example of where public comment will help clarify what the issues are going forward, and I think that's important.
Yeah. Thank you. All right, and with that, we can move on to item 7, public comment. Are there any members of the public here who wish to speak to the commission today? I don't see anybody. You may also send comments to the commission by mail or email at ccec@azcleanelections.gov. And if there's no public comments, we can move to adjournment. Is there a motion to adjourn? I hope.
Madam Chair.
I motion to adjourn.
Oh, all right. Commissioner Titla stole your thunder again, Commissioner Kimball. Maybe you can give us a second.
Second.
All right, thank you.
Second.
All right. Thank you. I'll call the roll again. Commissioner Titla.
Aye.
All right. Commissioner Meyer,
Aye.
Commissioner Kimball,
Aye.
and Commissioner Payton.
Aye.
And I vote aye. And with that, we are adjourned. Have a wonderful weekend, everybody. See you next month.
All right. Thank you.
Thank
Thank
you,
you.
everyone.